Ladies and gentlemen, Architect Liao, Mr. Chan, hope everyone is staying safe and good. I'm Ying, more known to my peers as Zawa. I'll be moderating today's webinar. If you notice, we already have a sign-in code displayed now. Please jot it down. And also remember to jot down the sign-up code later and fill in the Google form that will be shown. Wait a second, I need to clear this. Okay. We are also broadcasting the seminar live on our PAMNC Northern Chapter Facebook page. Feel free to share with your friends. However, there will be no CPT points for those who are viewing via FB page. Our topic today is about the Tanjung BUNGAH worksite tragedy with our speaker, Mr. Kean Li. On 21st October 2017, a deadly landslide in Tanjung BUNGAH occurred, claiming 11 lives. I remembered that Saturday morning, my previous employer called me and informed me about the incident. And for a split second, I was like, what? Oh no. Anyway, after the whole search and rescue, which took 3 days, the then Penang Governor, Tun Abdul Rahman Abbas, had on 6 December 2017 consented to the setting up of a State Commission of Inquiry, for short SCI, and was subsequently gazetted on 21st December. The hearing of the SCI lasted for 26 days, spreading for a good few months, and heard testimonies of 28 witnesses with opinions of 6 experts. The SCI's finding was finally released on 22nd July 2019. The objective of this talk is to highlight what are some of the challenges and issues that professional consultants in the building industry would have to navigate through if such a tragic situation were to befall upon a project site. Today, we are very grateful that Mr. Kean Li has accepted the invitation from PAMNC Northern Chapter to share with us his experience and professional views regarding this incident. Mr. Chan was representing the architect, which happened to be my previous boss. And during the course of the SCI, we have been among our colleagues saying that he is truly like a Tuapekong, or more accurately, a guardian protecting us. Not that because we feel that we are at fault, it's just we will never know what is going to happen in this kind of legal cases. We only know best what we do, but we don't know what may happen in court. Or this is not actually a court, but we still need our guardian. Anyway, Mr. Kean Li has been a member of the Malaysian Bar since 1997 and is an active advocate in the civil litigation practice. Chan's 20+ years of legal practice had led him to the construction law, where his legal services is retained to advise developers, contractors, and professionals in the building industry. Being an active, seasoned civil litigator, Chan constantly appears in the construction legal arena and has acted as lead counsel in arbitration proceedings, local council tribunals, appeals boards, and the Malaysian Civil Courts of Laws. One of the notable cases which Chan had acted for in the architectural field is the reported federal courts case of Loh Kok Beng and 49 Oz versus Loh Chiak Yong and Amor, 2015. Which determines the legal position of an architect's scope and duty of care in a project development. Chan is presently a senior partner of Gibb & Co., an established 19th century Malaysian legal firm. Before I pass on to others, should you have any questions during the talk, please type them in the Q&A box and we will answer them during Q&A session later. We might have a short break in between for short Q&A also, and another Q&A session at the end. So next, let's welcome our PAMNC Northern Chapter Chairman, Architect Liao Kuan Chung, to deliver the opening remarks. Over to you, Chairman.
Good morning, Zawa. Good morning to everybody. As usual, thank you very much for the attendees and all those people who are moderating and organizing the event, not least Gary's PXL and Co., PAM Secretariat, Pat, as efficient as ever. Thank you again, Zawa, for opening the session. And thank you, Architect Chong, CBD Chairman, for organizing the webinar as well. Last but not least, thank you, Mr. Chan, for taking the time to share your experience on the topic today. Just have a very small point I'd like to make before we go on to the talk by Mr. Chan. First and foremost, our thoughts and prayers are with the people and the victims of that tragedy and the family. No doubt, hope that there will be lesson learned, and hopefully incident like this will never happen again. Okay. Now, there have been a lot of rumbling in our architectural profession, especially in the Northern chapter after that incident. Not least actually when we, as PSB, sign on the building application drawings to say that we are responsible for all the construction work on site. I think maybe those words need to be looked into, perhaps together. Maybe today is a good forum for us to discuss that matter, I think. I can understand why when something happens on site, the architect or the PSB is the first port of call, because obviously, you know, being a PSB, they are responsible for the overall in terms of the running of the site. But I think I don't want to go back to 2017, how the MPPB handled it. I think it was not really done very well, in my opinion. Maybe this is not on behalf of Northern chapter. So basically the rephrasing and the connection in terms of the responsibility of PSB needs to be fine-tuned, I think, because obviously the PSB is the person that is actually responsible for organizing everything on site and overseeing the project, but they should not be the person that is actually being kind of blamed for the work without actually having done a really kind of overall investigation. As the saying goes in the legal profession, you are innocent until, you know, proven guilty. I think that is very, very important. So hopefully today, I think after Mr. Chan has actually presented, there may be some issues that will come up and provoke some questions that perhaps PAM Northern chapter and MPPB can actually liaise with each other and other professions as well to fine-tune the relationship in terms of the PSB and the responsibility on construction site. Okay, without further ado, please welcome Mr. Chan to share his thoughts and view on the matter. Thank you.
Good morning. Can you all hear me? Am I audible? Okay.
Yes.
You can hear me. All right, good. Well, it's a real honor, and indeed it is a real pleasure to be giving this talk. And I thank you for inviting me for the privilege of giving this talk this morning. Now, the subject of my talk, as Zawa has pointed out, is on the TANJUNG BUNGAH tragedy. And I wish at the outset to state my interest in the case, as I had the privilege, the honor of representing a distinguished member of your profession. And the objective that I hope to achieve through this talk this morning is to highlight to you, as Zawa has pointed out, what are some of the issues and challenges that we had to navigate together with the architect in that case, and in the hope that it also gives you an idea as to what you may face in such cases. The emphasis, of course, is on the undertakings that you have given, as Mr. Liao has pointed out. Those are major concerns because as we go on, you will observe that the line of thinking of the local council in respect of the undertakings and how they will want to hold, or they try to attempt to hold the architect accountable in that tragedy. Now, in so doing, I intend for this presentation to address the following. First, we will examine the challenges that threaten to lay the blame at the doorstep of the architect in that case. And in so doing, we will examine the arguments that was advanced by the various parties, in particular local council, where they sought to either lay the blame largely at the doorstep of the architect or at least apportion it together with the engineer. The objective of looking at these arguments, of course, like I said, it will hopefully bring to your attention what are the possible consequences that may arise as a result of decisions that you make as a result of your conduct in handling your projects as the consulting architect. We will then move on to take you through some of the arguments that we raised in the case that we represented a member of your profession. And of course, the objectives is to therefore highlight to you in law what are the protective measures that are accorded to you, what does your contract says, and how you can actually move to limit the scope of your responsibility and also the scope of your liability. And finally, what we will do is that we will examine the decision of the findings of the Commission of Inquiry, and from there we can perhaps examine and see what needs to be done moving on for your profession. Before addressing those points, I just want to, I know Zawa has mentioned when the tragedy occurred, but I just want to take us through very briefly again the tragedy. Prior to the tragic events on the 21st of October 2017, 3 minor landslips had already occurred on the project site, and they were on the 8th of August 2016, the 5th of May 2017, and the 11th of July 2017. Now, on the day of the tragic event, a group of foreign workers, what they were doing was they were preparing to the casting of the ground beam near a pile cap, what was identified as pile cap 179. At around 9 a.m., they were joined, of course, by Mr. Yuan, who was the site supervisor, and at around 9 a.m., the tragedy occurred. So the Commission of Inquiry was gazetted, it was set up, and its objectives, I will summarize the 3 main objectives that I want to emphasize today for the purposes of this talk. One, of course, to determine what was the cause of the tragic major landslip. Secondly, they wanted to ascertain whether the tragedy was due to any negligence, recklessness, breach of legal duty on the part of the parties that were involved in the development. And the final one that I wish to emphasize is that they wanted to basically determine which party was responsible for the tragic events that occurred. And the focus today of our talk will be on 3 parties, because these 3 parties were the ones that made the arguments against the architect. They were, of course, the consulting engineer. Secondly, I will take you through what local council made as their case, and they were the main player. In fact, the substantial arguments made against the architects actually came from local council, and I think it's important that you are aware of what they view, what their views are, in the hope that you can send your board to perhaps iron things out with them. And of course, then the last one was the Tanjung BUNGAH Residents Association. Now, on the consulting engineer's case, it was his case that our client, the architect, was the superintendent officer of the building works at the time of the tragedy. And that was essentially the base of his case. His contention was this, that as the SO, if the situation on site was determined or viewed to be unsafe for work, the authority to issue the stop work order lies with the architect. They say it does not lie with them. That was his case, that only the power to act in response to a threat of safety is with the architect. And therefore, their argument was that when the architect failed to issue the stop work order, he was responsible for the tragic consequences that ensued. And that was the extent of his case. It was short, brief, and that was it. Now, MBPP, on the other hand, had a lot more to say. They began in their written case when they referred the commission to the undertaking that I think A.R. Liao mentioned, the chairman mentioned earlier, given by the consulting architect. And this undertaking is one that you're familiar, it's endorsed on the building plan, and it was given by the architect in his capacity as the principal submitting person. And what I wish to emphasize is on the words of the undertaking, which is on the lower part. Saya mengesahkan bahawa kerja-kerja pembinaan akan dijalankan di bawah penilaian saya. The emphasis is that akan dijalankan di bawah penilaian saya. Now, their contention was this, that they referred the commission to bylaw 5 of the Uniform Building Bylaws. In that bylaw itself, it essentially requires qualified person or any person duly authorized by him to undertake the supervision of the erection and the setting out of the building. They therefore contended, and it was their submission, their case, that the undertaking given by the architect as a PSP in the building plan is akin to what they say is a pledge. They use the word promise, and they use it as a guarantee to local council. Those were essentially their words in their written case. And they therefore contended that this undertaking must, and they use the word must, be construed given by the architect, must be construed against him strictly. Those were the words that they used. Their argument was that the seriousness of an undertaking, it cannot be underestimated, and that the architect must be compelled to honor his undertakings. And then they went on to submit that any breach of these undertakings given by the architect to local council, it amounts to grave impropriety. And they say it's a serious dereliction of duty. They then said it had serious consequences under the Street Drainage and Buildings Act 1974, which I shall term as SDB. And they gave emphasis to Section 71 of the Act itself. And for the purposes of this, I want to emphasize on sub A, where they referred the commission to these words: misconstruction or lack of supervision during construction. And then they go on to say that the person responsible for such misconstruction or such lack of supervision, then he will be liable for the penalty that is stated in this act. So what then became apparent as their line of thought and the argument that was in pursuance of Section 70 sub 9 of the SDB. Now, the person that local council grants the commencement of works order, which we term as COW, in respect of the building works too, was the submitting person. And in our case, the submitting person was, of course, the consulting architect. So when the horrifying information of the events, the tragic tragedy, when they reached the local council, the party which local council and BPP issued the stop work order was to the submitting person, which was in this case the architect. And therefore they contended that since the architect had given the undertaking that all building works will be carried out under his supervision, he therefore owes a duty to the local council, to MPPP, to supervise, inspect the building works, to ensure that they are carried out in accordance with the approved building plans and in accordance with the required standards. They, of course, relied on an English case, the decision of Lord Justice Sachs, that said in Brickfield's property, and this is what his lordship said: the architect is under a continuing duty to check that his design will work in practice and to correct any errors which may emerge. It savors of the ridiculous for the architect to be able to say, true, my design was faulty, but of course I saw to it that the contractors followed it faithfully. Well, they relied on this authority and they submitted that the architect is under a continuing duty to review the design as necessary until the building works are completed in accordance with the building plans. Well, in our view, when we read this argument, we took the position that it was extremely unfortunate that it did not seem to matter to local council that the engineer had also provided a similar undertaking. Nor did it appear to strike the mind of local council that the tragic events were matters that were beyond the expertise of the architect. And in fact, that there was a specialist in a field, which was the engineer. And more importantly, they then went on to refer the very next instance of their written case, the undertaking by the consultant engineer, which was also endorsed on the building plan. So while they tried and they attempted to lay the blame with these undertakings on the doorstep of the architect, they also acknowledged that there was an undertaking given by the engineer. And in our view, this undertaking was extremely crucial, and it would be beneficial that we read out the parts, because the engineer gave this in his undertaking: saya mengesahkan bahawa kerja-kerja akan dijalankan adalah selamat dan kukuh, dan bahawa saya bersetuju bertanggungjawab penuh untuk keselamatan dan kekukuhan kerja yang akan dijalankan. So what happened was that MPPP then used the same arguments against the architect, against the engineer as well, implying or impressing upon the commission the importance of these undertakings on both the consultants. They then placed much stock on the Town and Country Planning Act and the SDB, and the relevant regulations requiring that planning permission or layout plan and building plan is to be submitted by a qualified person. So it became apparent in their case that consulting architect, because you are the principal submitting person, or in our case, he was the principal submitting person, who submitted the application for the planning permission, the layout plan and building plan. Their case was that he is also therefore responsible for the layout or setting of the building and the design and supervision of the main building works. That was their conclusion. This, of course, was despite that our client had testified that as he was only the contract administrator for the main building works, he was not involved in the earthworks and the piling works. He had also rightly testified that his responsibilities as an architect was confined only to architectural works, and that as PSP, his role was only to submit building plans and to issue CCC. MPPP did not, all this was actually noted by MPPP in their written case. But despite having noted all this and making references to this in their written case, they nevertheless took the position that since the architect agrees that he must supervise the work in which he is going to sign for, he is therefore also responsible for all undertakings given in the layout plan and building plan. They argue that in such circumstance, the architect would be equally responsible for the safety of the construction as well as that of the workers on site. Now, how did they come to this conclusion? Well, they argued that although your duty as an architect, or my client's duty as an architect, was primarily to his client because of the contractual relationships, but they say he would still be liable to counsel, and they went on to say to anyone sufficiently proximate and whom he should foresee that his act, or in this case failure, to take steps to ensure the safety of the site would cause damage to person and property. That, of course, would then enlarge the liability scope, not only to MPPP, but it obviously laid the foundation to enlarge the scope of liability to those who had passed on in that tragic incident. They further argued that since our client was engaged by the developer to design and supervise the construction of the building, they say it was incumbent, it was his duty to be concerned with the surrounding area where the building is erected. Their rationale is that to ensure the safety of the building that is to be constructed, the condition of the land on which it has been built must be evaluated to determine if it has potential adverse impact to the building. And they say, and they pointed out, that the architect had knowledge of the survey plans. Therefore, it was their argument that although the earthworks and the construction of the temporary slope was undeniably carried out by the consulting engineer, however, as the architect, he had a duty to ensure that the earthworks and the construction of the man-made slope is carried out in what they say a competent manner. They insisted that the architect must ensure that no soil from the temporary structure would come, and these were the words they used, come crashing down on his building design. That was the duty of the architect. So they were very clearly taking a position that because architect was the PSP, it became his duty to investigate whether the earthworks, the man-made slope that were carried out were properly designed, whether they were constructed to withstand any failure. In spite of the fact that there was a specialist, and it is of course beyond his expertise, they then went on to refer the commission to section 70 sub 21 SDB. When they referred this, they wanted to rely on this to support their contention that since the architect had the responsibility to supervise and ensure that the erection of the building is safe and fit for occupation, and in compliance with the approved plans and prevailing laws and regulations, it must therefore mean that the architect is also responsible for works carried on site, and that extends and includes earthworks and piling works. Their reading of section 70 sub 21 of the SDP was very interesting. They say that their reading is that the architect cannot delegate his liabilities and responsibilities. And even if there is a delegation of supervision of works, the responsibility and accountability remains with the architect. This is a point that was also picked up in the findings of the commission, and we will examine that at the end of this talk. So then MPPP applied their reading of this provision, and they concluded that the architect may not be responsible to supervise the earthworks SPSP. They admit he may not be responsible to supervise it, since he was the only person who can sign the CCC. He is to be accountable for the building works, earthworks, and therefore the safety of the construction site. I'm not sure how this resonates with members of your profession upon hearing this, but that was the argument they made against my client. And all this is being emphasized because it became apparent that although the temporary structure was designed by the engineer and not our client, nevertheless, we were extremely then mindful that the principle of assumption of responsibility was going to be a vital issue of dispute, whether or not our client had assumed the responsibility and therefore extended the liability. I therefore wish to emphasize to your members that the principle of assumption of responsibility, that it is very essential that you are aware that your scope of duties and your responsibilities are set up, the parameters of it, and that once it is set out in written form, that you do not stray from that itself, that your acts and your conduct is consistent with what has been set out in the contracts. Otherwise, it could and it would be extended to, the liability be extended to you. So that was their case. In short, they basically were looking for statutory provisions. They relied on the undertakings that the PSP gave, and from there, they extended and stretched the liability from the engineer and then apportioned it to you, in spite of acknowledging that the architect does not possess the expertise. It was beyond his expertise, and there was an engineer, and that the temporary structure that collapsed was designed by the engineer, yet they took the position that the architect has to be accountable because of the undertakings and the pledge and guarantee that he has given. So that's their case. TBRA, on the other hand, then went on to place emphasis on the following. TBRA being the Tanjung BUNGAH Residents Association, their case was structured along these lines. They say firstly that our client was the architect of the project, He was the PSP for the layout and building plans. He was the contract administrator of the building works. He was, for the main building works, he was the superintending officer. And I quote what TBRA used in their written case. His job, the architect's job, kicked in when the building contractor took over possession of the work site. That was the words that they used. And they made reference to the testimony of the engineer regarding the development proposal report. Now, the engineer in testimony, he claimed that he did not know what is required to be in the LCP, but he says if there was any specific thing from the engineering features that is required to be included, normally, he says the architect will request from the engineer to provide such information. That was his testimony. And so the case that the TBRA sought to make against the architect was the architect has a duty under the TCPA to provide all details needed in relation to the layout plans. It was their case that such required details would include those of the proposed earthworks, and they relied on two provisions. One, Section 21A, and the other Section 21B of the TCPA to support this contention. They argued that if the architect relied on the engineer, then the architect ought to have obtained all the relevant details regarding the temporary works. They contended that it ought to have been done as it would have assisted both MBPP and the OSC to decide at the outset if planning approval ought to have been granted. And then they went on to say that the consulting architect must have surely known, and they used these words, or should have at least made efforts to discover the nature of the earthworks involved at the time of the application of the planning permission. They relied on Section 21B Section 21B 1A sub 7 of the TCPA because it refers to the proposed earthworks. All this in the slides will be given to you as notes. They therefore contended their submission that not disclosing the information about the proposed earthworks, they say, was a breach under the TCPA. And they submitted that because the architect knew about the slope stabilization works, our client, the architect, cannot take the position that the consulting engineer could and should have considered stopping the earthworks without the need of the architect. Because we have always contended that this is within your purview. The stop work order has to be issued by you because you know what is best. But their contention was that that's not the case because of this provision. And so they again laid the responsibility at the doorstep of our client, the architect. Essentially what they are saying is this, that you, the architect, you cannot escape culpability. Your hands are just as much in this as the engineer. And they said that that is because you had a duty under the TCPA, the Occupational Safety and Health Act 1994, and the SDB. So that's basically the case that all three parties made against our client. And before I move on to what an architect needs to know, I'll be very keen to hear if there's any questions that you may have regarding what I have just brought to your attention, especially where counsel is concerned, because I understand that you have a lot of dealings with counsel. And so in case it raises some concerns, this will be a good time for us to see whether we can address them for you.
I think there's no question for the time being. Regarding the undertaking that you mentioned that the architects put on the plan and UBBR, the bylaw, well, actually bylaw did mention it should be under the supervision of a qualified person, where so different, every professional, they have different qualification. And I do agree with your point of view. It's just how they pointed to the architect, which is yeah. I think Casey also did address that they have some changes on this undertaking, or if not, then we may have to actually take some action on with PAMNC, with our HQ to discuss this with the council on all this undertaking nowadays.
Yeah, I think you've made a point that I'm going to address shortly about the duties and also the statute about principal submitting person. That is a point that we relied heavily on in our case, and I'm going to come to that shortly in order to weave and present to members of your profession which are the provisions that gives you some form of protection, and also which are the statutes that you can rely on, and more importantly, how you can then transfer that responsibility very clearly to the engineers because of what their own code of conduct stipulates, which was heavily relied upon by us in the case that we made for and on behalf of our architect client. But I must caution that when we presented this, we had no idea what the findings of the commission would be. And we thought when we presented the arguments, or when we made our case, that these were exceedingly strong arguments. In particular, one specific provision that I'm going to point out in the PAMNC contract 2006. But when the findings came out, we were taken aback to the extent that there was an observation made by the commission that one of the provisions that we relied on in the PAMNC contract, it is not as all encompassing kind of a defense against situations such as this. And the commission made an observation on that, which I'm going to highlight. And I think that is something that you will need to look at, because that was partly a main pillar of our defense when we made our case to the commission. So do you want me to continue or do you want a break?
Do you need a break?
No, I'm fine. I'm just worried whether if I continue talking, I'll put everybody to sleep.
Yeah, okay.
All right, if that's the case, then
interesting.
Right. Well, let's go on then.
Yep. Thank you.
Because you have first-hand experience as well. We can go on so that we can all perhaps end early, and then you can go for your lunch, so your tummy will not be rumbling and you're thinking of your lunch. Okay, so let's look at what an architect needs to know in such situation. Now, when we accepted the brief, the first thing that we felt that we needed to establish, and this is an essential thing that architects need to know. We need to determine what exactly was the scope of responsibilities that govern the works in a said project. That's the first thing that you always need to start with. Your lawyers will want to examine the documents. They will want to examine your conduct, and that you need to be very consistent and very clear. And why do we say that? Because in the case of Loh Kok Beng and others, 49 others against Loh Chiat Yong and another, this is a federal court case which we had the privilege of representing two other distinguished members of your profession. And the federal court made this observation. Nevertheless, it must be reiterated that a claim for negligence must be brought within the scope of duty of care. It would not be fair, they say, just and reasonable to impose on the respondents, architects in that case, a duty of care for a responsibility which they had not assumed or one which was not within their professional scope of duty. So this was critical. Why do I say assumption of responsibility is this? You may take the position that I only have expertise in this, but if you demonstrate that you had gone on to demonstrate that in matters that are beyond your expertise, that is where the principal assumption of responsibility removes that shield that you can rely on. So that is why it is always essential to examine both the conduct and what's stipulated in the contract. Now, in our case, what we then established from the commencement of the proceedings was that our client was only serving as our client was not serving, in fact, as administrator for earthworks and piling works. That administrator was the engineer. That was the first thing that we succeeded in establishing. And we then went on to establish that it was a direct appointment between the developer and the said consulting engineer. In short, on contract, our client had nothing to do with both the earthworks and the piling works. And we wanted to do this because on contract, it was something that we wanted to refer to the commission, and you would need to refer to the courts. Here, it says very clearly what my scope of responsibilities are. I have nothing to do with these two areas. And then we further then went on to rely on the following provisions that we want to give emphasis. Article 4 of your PAMNC contract was essential to us, and so was condition 1.2. Because Article 4, it specifies whom the engineer in the contract is. And then it goes on to state that the engineer shall perform the duties expected of his profession, and the architect may from time to time delegate such duties and authority of the architect to the engineer as the architect deems fit. And that was something that we could rely on. And then the second one is the conditions of contract, condition 1.2, the heading of temporary work and construction method. And they provided this, unless designed by the architect or consultant, the contractor shall be fully responsible for the adequacy, stability, and safety of all temporary works and of all methods of construction of the works, irrespective of any approval by the architect or consultant. So these provisions, in our view, we could not overstate the importance, overstate enough the importance of it. In fact, they were our pillars when we built our case. And I want you to pay attention to condition 1.2 because it evidently, on the reading of it, it appears to absolve my client and architects from liability. But later, when we look at the findings of the commission, they do not appear to be persuaded that this provision alone is sufficient. And that itself, therefore, when we take into account the arguments and the case of MBPP, especially the emphasis on the undertakings, I think it's a point of concern that you will need to address. Now, why are these provisions important? Well, it allows you, the architect, your lawyers, when they represent you, to establish the legal proposition that the SO for the earthworks and temporary works to supervise would be the engineer and not the architect. And it would give you the basis to establish that both in law and fact, the engineer in the project being the design engineer of the earthworks, particularly the temporary works, is the consultant responsible for the supervision of the work regarding its stability and safety. Now, this agreed scope of responsibility is consistent with the following provisions, which in such cases, we say that it is essential that the architect relies on this because it sets out the difference in the scope of duties for consultants in such projects. The first being the Board of Engineers Malaysia, the role and responsibility of professional engineers for temporary works during construction stage. The second being Board of Engineers Malaysia Code of Conduct of Registered Person. The third, Board of Engineers Malaysia Supervision of Construction Works. The fourth, Lembaga Jurutera Malaysia. And the last being the Registration of Engineers Regulation 1990. Under the code of conduct, the registered person, it states the following. Registered professional engineer with practicing certificate to certify if he has control over supervision. And then it goes on to say, a registered professional engineer with practicing certificate shall certify satisfactory completion of a piece of work only if he has control over the supervision of the construction or installation of that work, and only if he is satisfied that the construction or installation has fulfilled the requirements of the engineering design specifications. So in such cases, when we rely on this, then it will go hand in hand with the determination next of who actually signs the 10 G forms. And that is because in G forms, G form 1 being for earthworks, while G form 4, G4 is for structural, and they contain the following words. Kami memperakui bahawa kami telah mengawasi dan atau menjalankan pembinaan dan penyiapan kerja-kerja tanah. So it allows your lawyers to then argue, as it was in our case, that by signing these forms, the person doing so, which was the engineer in our case, acknowledges and recognizes that it was his scope of duty to supervise the works and the contractor for having done the work. And of course, in our case, it was great assistance when the engineer admitted on testimony during the proceedings that a registered engineer would have to certify that the work has been carried out according to his design, requirements and bylaws, construction drawings, as well as supervision, and crucially, he says to take full responsibility of the work. That was the words that he used. Under the Board of Engineers Malaysia Circular for Supervision of Construction Works, this further provides you another avenue to defend your position. There's Act 133 only allows qualified person to supervise and certify completion of construction of engineering aspects of buildings. No erection or continuation of erection of that building works shall take place unless that qualified person or any person duly authorized by him undertakes the supervision of works. This means that the submitting person shall supervise the construction works, and a submitting person shall not certify of construction work unless he or any person duly authorized by him has carried out supervision. I'm afraid the slides here are very small. I'm not that proficient with computer. If you really require, any of the members require these circulars, I'll be happy to extend a copy to you all. Now, it would be therefore essential in my view that in cases such as this, that we establish, as it was here, that for engineering works, this submitting person was not the architect, but it was the project engineer. It is also in our view, my view, that both the architects are aware that there was actually a guideline through a joint meeting that was held between your board and the Board of Engineers. They jointly set up the job scope for consultants, and this was actually given to us, and it was extremely beneficial. May I take you to the appendix, because the appendix lists the works and or services, the engineering plans, reports, and specifications, which may only be submitted by professional engineers. And it says, no person shall submit any engineering plans, reports, and specifications for the underlisted works and or services unless he is a professional engineer, except for any architectural works required. Such architectural works shall be submitted by an architect. And they list among the services earthworks, foundations, pilings, major retaining walls, stabilizing wall structures and structural systems. Now, what happened in our case was that we managed to establish that the stabilization and strengthening of the slope was based on the engineer's design. And in such instances, such projects, architects can then rely on the guidelines of role and responsibility of engineers for temporary works during construction stage. Because it says here that although temporary works are mainly the contractor's responsibility, it is, however, important that professional engineer involved in the project, either as owner, consultant, or contractor, he plays an important role, an active role in ensuring safety. And the code of conduct set up by the Board of Engineers under Registration of Engineers Regulations 1990 requires that the registered person shall take reasonable steps to reduce foreseeable effects of professional engineering services on the environment. So this, together with what was condition 1.2, which I emphasized, they essentially were what we made our case to the SCI. Now, when there are two consultants in a project, the undertaking provided by the engineer as the submitting engineering consultant in the earthwork plans and layout plans are essential. And I think, Zawa, you mentioned this about this interpretation in the SDB. Section 3 of the interpretation, they talk about who the principal submitting person should be. Then they go on to define whom the qualified person should be. And then you go on to say that a submitting person, I think you mentioned that, means a qualified person who submits plans other than building plans to the local authority or relevant statutory authority in accordance with this act or any bylaws made thereunder, and includes any other qualified person who takes over the duties and responsibilities of or acts the first mentioned qualified person. And then section 70 sub 20, these are all very important provisions which we are going to provide to you all. They are provisions that are very important in our view because they impose the responsibility over the earthworks on the consulting engineer. They mark out what exactly are the duties, especially in instances where you have two consultants. And that was where we relied heavily on this. Now, in cases such as this, the following undertakings also allows you to distance from being responsible for events that are as a result of the earthworks design. The undertaking being Mr. Lu, I will get back to you shortly on your question. I've noted your question. When I finish this, I'll come back to you. Now, undertaking on the approval plan. Saya mengesahkan bahawa kemajuan ini tidak akan mengganggu sistem saliran di sekeliling kawasan ini. This is given by the engineer. Saya mengesahkan bahawa kerja-kerja yang akan dijalankan adalah selamat dan kukuh, dan bahawa saya bersetuju bertanggungjawab penuh untuk keselamatan dan kekukuhan kerja yang akan dijalankan. Saya mengesahkan bahawa alas dan binaan boleh menahan muatan tambahan dan atau kegunaan baru. The undertaking on the earthwork plans also says this. Saya bertanggungjawab terhadap segala reka bentuk penyeliaan dan pengawasan bagi semua kerja-kerja yang berhubung dengan kerja tanah. Bertanggungjawab sepenuhnya untuk penyeliaan untuk reka bentuk konkrit, wall, cerun batu, tapak adalah stabil, dan saya bertanggungjawab ke atas kestabilannya. And then the third layout plan is that undertaking on the layout plan, saya mengesahkan bahawa kerja-kerja yang dijalankan adalah selamat dan bahawa saya bertanggungjawab penuh untuk keselamatan dan kekukuhan kerja yang akan dijalankan. If such an instance were to occur to any of the members of your board, of your profession, I think, in my view, that your lawyers their attention need to be drawn to the existence of such undertakings, because it would, in that sense, allow your lawyers the confidence in shaping how they want to represent you and how they would want to move the responsibilities to the engineers. Because these undertakings, they are very clear as to who is responsible in these areas of work, the project. In our view, these undertakings allows you to rely on the skill, the expertise of engineers. It therefore means that you can therefore avoid the principal assumption of responsibility being extended to use against you. Now, as a point of interest, I think that this is something that you would need to know. Along the way, during the proceedings, we encountered a little bit of a hiccup because MPPP had suggested that our client had failed, and they used this word, sir, in providing a full and frank disclosure in the discharge of its duties as PSP regarding the earthworks. But why did they say that? They alleged that my client did not fulfill and did not comply with what they term as honest system practiced by MPPP. I'm not sure whether members of your profession are familiar with this term honest system, but that was the term that they used. And that is because their MPPP planner from the Jabatan Pembangunan, when he took the stand, he gave the following testimony, oral testimony. And he says this, listen to these words. He says, and I'm quoting him, daripada peringkat awal, sepatutnya pihak jurutera atau arkitek dah tahu, that means you should know, desain bangunan tersebut dan tahu lebih kurang berapa cerun akan dipotong. Perkara-perkara tersebut sepatutnya dinyatakan di dalam laporan cadangan pemajuan dan di dalam plan susun atur yang dikemukakan supaya relevant technical department dapat mengulas sewajarnya. And that led to the need for the commission to examine the senarai semak permohonan kebenaran merancang. I'm not sure whether Zawa you remember during the proceedings, we had to really cross-examine because he went on to say, pihak pemaju diberi pilihan sama ada hendak kemukakan permohonan KM sahaja ataupun secara serentak KM bersama plan bangunan bersama plan kerja tanah. Now, he was then asked the following questions from the chairman of the commission, Datuk Yeo Yang Po. And this was the exchange between him and Yeo Yang Po. Datuk Yeo asked him, you also say that there are two procedures for applying for planning permission. Satu serentak atau satu lagi tidak serentak. From the planning point of view, which one is a better procedure? Serentak atau tidak serentak lebih sesuai dari segi planning? His reply, dari segi planning, mana-mana pun kami okey. Tiada perbezaan, he says. Serentak atau tidak serentak hanya akan memberi kelebihan kepada pemohon sama ada nak expedite ataupun tidak. So Dato' Yeo then went on to ask him, now you have this problem. Tidak serentak, so disclosure comes much later. Selepas ini today, you also think there are two procedures as he says standing. Now, the reply, pada pandangan saya, sewaktu pemohon mengemukakan KM, pihak PSP dan yang satu tim dengan itu perlu jujur mengemukakan apa dan memberitahu keseluruhan tapak pembangunan tersebut dan tidak hide something. Those were the words verbatim that he said in the transcripts. He went on to say, bagi saya, sewaktu KM, pihak pemaju ataupun PSP sudah tahu jenis pembangunan yang hendak dimajukan dan bagaimana bangunan tersebut hendaklah didirikan dan keadaan topografi tapak tersebut. So daripada itu, segala perkara-perkara yang perlu dinyatakan di atas plan dan laporan kemajuan dan beberapa dokumen yang berkaitan sepatutnya dinyatakan. So dari situ, permohonan dikemukakan secara serentak atau tidak, bagi saya sama sahaja. He said this, as long as semua maklumat mengenai cadangan pembangunan dinyatakan dalam dokumen-dokumen yang berkaitan. Now, from this itself, we established was that an architect or a PSP, you can choose whichever form, whether serentak atau tidak serentak. It appears that there's no guideline as to which form you should choose. And that was also what our client informed us that that's the practice. Now, in the Granito case, in our case itself, the form that was chosen, it did not have the earthwork plans. And during the examination of the planner himself, we were able to obtain from him the answer yes to our question that at the stage of the KM application, since a choice is available to the PSP, if he or she chooses serentak or tidak serentak in this case, and do not include earthwork plans, would he agree that it cannot be a non-disclosure? Because it's a choice. You have a choice. How can that be a non-disclosure? And furthermore, there are no guidelines. And he agreed with us that there cannot be a non-disclosure because that was a choice. But what is important for you to note here is that despite his testimony, and despite what we had established from that exchange between Dr. Yo and the person concerned, MBPP, in their written case, they maintained against the architect that there was still non-disclosure, there was non-compliance with the honor system. Those were the exact statements that they used. In their written case, MBPP argued that the details of the proposed earthworks, if any, you should be stated at the development proposal report, which is prepared and submitted by the PSP. It was their contention that as a DPR, the proposal report was prepared by the architect as PSP. He would have received the necessary inputs of earthworks from the engineer, and then he is therefore accountable to disclose in full all details relating to the earthworks to be carried out. And they say the need for this full and frank disclosure is the responsibility of the architect as PSP, because the local council and BPP would rely on the representations given by the PSP in the DPR. And then they went on to submit that any omission by the architect in our case to specify in detail the earthworks, they claim that it absolves them from any responsibility because of the honor system in place. And of course, this line of argument was also adopted by TBRA because they were insistent that the architect had a duty to find out and disclose to MBPP the nature of the earthworks involved at the time of the application for the planning permission. In my view, why I brought this up is because I think it is essential that your committee, the members of your board, speaks to MBPP about this and sort this out, so as to ensure that this choice that's given to you would not result in future such charges made against the architect concerned. It's important that we sort this out. Now, on a final note, I just want to point this out that when we were preparing this case from day one, it was extremely beneficial to us as lawyers that our architect and his team, which included Ms. Zawa, Ms. Ng, they were very proactive, and their contribution and ability to be on the ball with the details was extremely beneficial to us. I think that in such cases, what architects need to do and remember is that after the shock has set in knowing that a project you're involved in has these events that has occurred, you need to first and foremost, as was with our client, we advised him, sit down very calmly as best as you can, write out immediately what you can recollect about the case. And then at the same time, pour through your site meetings, your reports and all this, get them ready. Because we as lawyers will need to look at that. We will need your input. We will need you to give us some form of guidance as to what had happened. We need to know the chronology, the details of it. And the technical input that was given to us by the architect and his team was extremely beneficial in helping us at the very outset to shape how the defense that we wanted and the case that we wanted to make for the architect. So what are the findings of the commission? I'll finish this up, I'll wrap this up, and then let's look at the questions after that. Firstly, the commission said this. They said that for any acceptance of the rule, as SO of any project, they agreed that there must be clear demarcation of duties. That was what we also took the position. There must be a clear exclusion of responsibility on all engineering matters. And then they said this, it is missing in the present common practice in the building industry. That is what they say. And then they went on to say, while it is acceptable and understandable why architects want to be SO, and they say reason is being control over matters of administration of contracts, over matters that have financial implications, the architects must be careful to confine the powers and duties to matters of administration of contracts. The Commission observed that this is necessary if it does not want to invite the visitation on unintended liability upon the architect on engineering matters. And then they went on to say, presently it is observed that architects appear content to leave the proper scope of an SO's duties to be subjected to an influence in the interpretation of their contracts. And crucially, the Commission, they say they are not convinced that Section A.12 of the BQ in the PAMNC contract 2006 is clear enough. They say this because they take the view that deputizing of duties is a different thing altogether from disclaimer of responsibility. And I must agree that in this case, we had to use both the contracts, the codes of conduct of the engineering, examining and placing emphasis on the conduct of the architect, making sure that he has never strayed beyond his job scope, and that all the matters relating to temporary scope, temporary slope was done by and only the engineer in order to provide that influence in the interpretation as to what the job scope was. So they then concluded that while they accepted that it would not make sense to hold that contracting parties would have wanted, in our case, to put an architect in charge of oversight of matters relating to engineering, they issued the following warning, which architects would do well to take heed. That if architects continue to ignore the present deficiency in their contracts on clearly spelling out the job scope and duties of the SO, architects would be subjecting themselves to the very real possibility of a different interpretation by the courts of their contract. Architects could then have to shoulder some form of liability. And that was the findings of the Commission. And I think that in our view, it would do well to take heed. It may be extremely beneficial that your board relooks at your contracts, specifically in condition 1.2, and how you can improve on those contracts to clearly mark out what are the job scope as an SO. I'll take your questions now. I'm happy to take your questions now.
Kenny, there are some from the chat box, and there are also some from the Q&A box.
Oh, so which one do I go first?
Any one you prefer?
Okay, I did promise.
BUNGAH.
Yeah, where is his? I'm curious to look at his.
It's in the chat.
Okay, I'll look at it. Maybe somebody can help me. Which question is that?
I think BUNGAH mentioned in the eyes of the law, how is the term reasonable being defined by the court of law?
Well, I'm curious to find out what do you mean, how is the term reasonable being defined, in what context? Are you talking about context or whether it's reasonable to extend the responsibility of earthworks to architect? Because reasonable, the word reasonable cannot be taken on its own. It has to be fitted to a particular situation. And then only can you argue your case whether or not it's reasonable in the circumstance. In this case, of course, we would argue, and we have good reason to argue, that it would not be reasonable to expect an architect to issue a stop work order because he would not know whether or not there is already pending danger, and more so because there was already a consulting engineer who was taking remedial works, and he should be the person most reasonable to determine if there is a safety issue and whether or not works should have stopped at that point in time. So the word reasonable, legal context in that sense would be very, very appropriate to afford the architect, as in our case, a defense. Does that answer your question, Bunha? I'm not sure.
Yes, Bunha answered, yes, yeah.
All right, then I'll take the next question from an anonymous attendee. All right, why did it come after the architect when SDPA or UBBL has the following provisions? Engineering is the SP, engineers, science, approach, borang, beef. Why does PSP is required to be responsible for all SP, since these are areas of highly specific specialties? I am in total agreement with you on that one. I can understand why the engineer wanted to shift part of the blame to our client. I can totally appreciate that. But I'm in agreement because it was very, very surprising and perturbing, also very distressing to my client at that time, I could recall. The same question occurred to us. Why did the local council especially make such a spirited case and challenge to try and lay the blame or some part of it on our client, given the fact that the acts and the facts itself would have demonstrated that our client was not involved on these matters concerning the earthworks. But as I pointed out, which is why I thought it was beneficial that we examine their arguments, they attacked on the undertakings that you gave as a PSP. And I think those are areas that you would need to address with them. You would need to have some form in written form that moving on, they will know that architects cannot and should not be held responsible in such situations. But I'm in total agreement with you. It was the same surprise and horror when we read their case. And in fact, a lot of our responses was devoted in I would say about 80% was devoted to responding to these arguments to point out that why on the facts and on the law, my client should not be held responsible. My next question, Lin Chua, the PAM contract clauses are able to override the SDPA provisions for responsibility during construction works, or is it sort of like a back-to-back responsibility? Well, my first answer to you, I'm not sure is it Miss or Mr. Chua. I apologize because I can't really detect, but my first answer to you is this. Contractual provisions can never supersede statutory provisions. Okay, so let's be very clear. Case laws have long established that statutes prevail over contracts. So you can contract anything you want, but if the statutes do not permit it, the courts will not recognize it. That's the first point I wish to make. So essentially, when we look at a case like that, the strategy of your lawyers and yourself will be to ensure that the provisions that you are relying on, they are in tandem and they are consistent with the statutory provisions, and your conduct itself runs consistently with both. So I'm not sure what you meant by back-to-back responsibility, but I want to make it very clear that the contractual provisions, they must be consistent with the SDPA, and they cannot override. I think the problem now is that it's not only on these two that the attacks appear to have come from. It appeared that much thought was given on the undertakings that you give. Because undertakings are, like they say, akin to a pledge, a promise, a guarantee, and they want to hold you accountable. And so I remember that I think Mr. Liao mentioned, A.R. Liao mentioned at the outset that wordings on the undertakings, I think specific care must be placed on that, so that it runs in tandem with what is inside the PAM contract and what's provided in statute. And I think the Commission is also making an observation on that, that is where the problem lies. I hope that answers your question. I'll go on to W.C. Lau. If the KM was submitted by the town planner, what will be his or her liability in this case? Good question. It was never observed. It was never explored. But my answer to you would again be that it would depend on what was the undertakings that he gave. Would like to answer this. Yes, please. Sorry, A.R. Zawa would like to answer this question live. I see. Sorry.
Clear that.
What does that mean? That means I answered that live, right?
Yes.
Does that mean, okay, because I thought maybe you are going to take over, so I'm fine with that.
Yeah.
You could assist me.
Yeah.
I really, I guess it was going to be very difficult to answer you in a nutshell. Because if you look at it, they not only use the fact that you submitted the KM, they actually piece, in the case law, you must always understand that it's a matter of jigsaw puzzle, piecing together the various pieces and then building your case. And in this instance, the MPPP, of course, they took into account that the KM was submitted by the PSP, which was my client. Then they took into account the undertakings, and then they went on to other things as well. So it's a culmination of things, which that's why when we took you through what was our case, we also demonstrated that we also needed a combination of things in order to repel the attacks. So I really would not be able to pinpoint what will be his or her liability. And it also will depend on the circumstances, the facts, and what the town planner did apart from just submitting that thing itself. What is PAM's stand on the finding of the commission? Any actions thereafter? I really do not know. I think that one is more for the board to answer. I'll move on to the next one, but it's a good question. I think it is something that you really need to address, and I hope that this talk will raise that awareness. Why the commission only refer to the responsibility or scope of work stipulated in PAM contract? In my opinion, that the matrix of responsibility was also clearly stated in UBBL, especially in G forms, SDPA, etc. What if it's other forms of contract like JKR, which generally the SO was not the architect? I'm afraid that is an answer that only the commission can answer, but perhaps I guess that, well, my recollection was that from the very outset, I think it weighed on the minds of the commission that the architect should not be held responsible. I recollect very clearly that the chairman, Dr. Yu, asked me, does your client need to be involved in these proceedings? Which we quickly replied, no. We say no, and we gave the reasons. And he was already very keen to dismiss the participation of the architect, my recollection. Zawa can correct me if I'm wrong. But unfortunately for us, both TBRA and MDPP decided that we should remain in the party. They felt the more the merrier. They wanted our company. They valued it very much. So we then unfortunately had to remain in those proceedings. And I think that was why when the commission delivered its findings, it only focused on what they felt is a shortcoming in your building industry, and then they did not see the need to go further. So that would be my answer to you. But I agree that both the SDPA and UBBL, the G forms especially, and the undertaking, that one by the engineer, they are extremely beneficial. Feel like the local authority is approaching the case from perspective of fault in design as well. Wondering if there was any discussion on the local authority's role as controller in a Well, I'm very minded that this is on live Facebook. So I'm going to just approach your answer in this manner. It was, I believe, the commission was perturbed by the fact that although the council has a department that deals with engineering matters, there were concerns that whether or not when you choose to put the responsibility entirely on the engineer, and in this case to even extend to the architect, whether it would appear that your department is there to, how do I tactfully say this, simply just accept and approve the thing, and therefore you put the onus purely on the engineer and the architect to ensure that all is all right, and that you have no other role, supervisory role to play. And I think that was one of the issues that was raised in the commission report, if I'm not mistaken. You can always get a copy of the report. I think that is also where your board needs to emphasize in a meeting with local council, emphasize to them, in my view, that, hey, if you have a department devoted to engineering matters, then it would not in future be appropriate for you or your lawyers to then, in a case such as this, to suggest and impose that responsibility on us, and then perhaps get that sorted out in black and white as a guideline, and so that in future your members of your profession will not have to face the stress that I saw my client going through. Architects have no choice on the undertakings, on the plans. It's a requirement, yes. That is exactly the same, that was exactly the same comment that my clients made. It is something that you require of us, and now you hold it against us. And that is why I think you really need to deal with this, because it has been left in the open, and we were extremely fortunate in this case that the facts favored us. We are concerned that what if, for some reason, an architect stepped slightly beyond its boundaries of the scope of duty, and then this undertaking that you are required to give, and you do give, and now it comes back to haunt you for something that's beyond your expertise. And so I think, Mr. Ao, you are absolutely correct. You have no choice presently. I think you need to sit down with them. You need to revise the words of undertakings. And bear in mind, undertakings are viewed extremely with absolute seriousness by the courts of law. They give undertakings a lot of emphasis. There are very, very little room to maneuver, because once you give an undertaking, it is equivalent to a guarantee, like they said, and you cannot move from that. It has legal connotations. So when we happily give the undertaking, all is fine. It's a matter of what we term as, it's a requirement, so we give. It is only when such an instance occurs that we now realize that these undertakings, how it can be used in a court of law, in a commission, to come back and create and make a case against us, against the architects. And then we will have to scramble positions to defend against it. So I think those are the concerns that even the commission, the observations the commissions made, and we certainly experienced it when we were defending our client. Are there any other questions that I may have missed?
Yes, Kenny, some of them typed in the chat box. Let me go up. Yep.
Just a moment. Yeah, yes.
Before BUNGAH, there's one, Lim Woon Han.
Okay, I'm trying to go to that. Sorry, lawyers are not that proficient in computers, just well, in my case at least. So
it's all right.
I'm trying to find the question. I'm sorry, I do apologize. Which one before? Okay, whose question is that?
Lim Woon Han.
Lim Woon Han. Okay,
yeah.
let's.
He has two questions. That's number one, like some job, the client appoint the architect and engineer separately and give only the engineer monetary fees for earthwork and piling.
Yes, yes, and that was essential to our case, if you recall. When we took up the case, the first thing that our client impressed upon us, and we established this very outset in the proceedings, we grilled the developer to establish this, or we asked them to establish this for us, that the engineer was appointed directly by the client, and they were appointed for earthworks and piling. And that's a very good position to take, because it immediately demonstrates that nowhere contractually did an architect assume the responsibility for earthworks and pilings, because no money passed through him. And the appointment was also not through him. I would want to emphasize that in such cases, it is good practice, because of this case, that when it comes to engineer earthworks and piling works, that any contract, any appointment, it will be direct from the client developer, the employer, and that the architect stays out of it. And the appointment to the architect is only for what his work is, and limits to that. That would be my answer. I hope that answers you, Mr. Lim. If you have a follow-up question, please let me know. Your second question is, other clients employ both, include monetary for both, in this case, are both responsible jointly? Yes. I see your question. Other clients employ both consultants and include monetary fees for both consultants. In this case, are both consultants responsible jointly for piling and earthworks due to the principle of receiving payment? I think that is where the commission has raised that issue of blurriness, demarcation, because if you do appoint jointly, and when there is payment received through you, I would think that there is, to a certain extent, at least some platform to build a case. And then it would then very much depend on what you do next. What are your acts next? How you participated in the project. It will have to be a very detailed examination, because now the contracts itself does not provide you an outright demarcation of duties on paper, and therefore you would have to really build your case only on the pillar of what you do next. So that would be my answer to you. Any other questions? I'm very keen to see what.
Yes.
Okay, Mr. Patrick Ng, is it?
Yes.
Is that the next one? Okay. The architect, who is usually the contract administrator of the project, will conduct periodic site meetings and technical meetings. Hence, would it be sufficient to say that the architect had done his due diligence, have taken reasonable steps in executing his duty of care? If you were to just ask, pertaining and or asking the engineers in ensuring the safety of the slope design, and does not provide any solution, as we are not trained nor an expert in engineering design. That is an excellent question. May I tell you why? In our case, we had that experience, which I didn't think that it would be necessary to raise this in the talk, but now that you brought this question, it prompts me to. In our case, it was brought to the attention of the commission that our client, as the architect, had sat through the meetings, the site meetings. And during that site meeting, a memo was circulated by the safety officer of the contractor. And the safety officer raised the memo, in that memo, to suggest that there is an issue of safety work on site. It was their case, therefore, that to suggest that because of the memo, we had knowledge, and therefore it links up with the engineer's case that because we had knowledge, and because they say that we are the contract administrator, the SO in that instance. So therefore, the right to exercise the stop work order laid solely with our client and not with them, and that was the case that they wanted to make as well because of that memo. So knowledge was imputed. Our client did nothing. That's what they're saying. Our contention, of course, in that instance was that, hey, it's not that we didn't do anything. We had and we established that the engineer was taking remedial steps. And so although knowledge was imputed that there was that there could be an issue of safety, but that safety and the condition of the temporary slope was being examined and attended to by the engineer, who had demonstrated that he is supposed to be an expert in that area. And it is his design. So it would not make sense for us as an architect with that knowledge to simply issue a stop work order when the engineer does not do so. So my answer to you is that to ask questions pertaining and or asking engineer to assuring, yes, I think it is very important. It's good that you ask. It is extremely important that in the site meetings, it is established that any issues of safety or concern, that the engineer is on top of it and he provides the accountability and the assurance that he is looking into it. And then that allows you as an architect to rely on the fact that you have done your job in raising the concern and that ensuring that it is being attended to on matters that are not within your expertise. So that would be beneficial, as was in this case. That's what we did. Okay.
So,
yes.
Sorry. So for like this case, in this instance, definitely we know that there's this engineer on board and taking care of the matter.
Right.
So what if like in the meetings, there are no records that on this matter? Do you think the architect may be also partly held responsible that we did not ensure that someone qualified is attending to that matter?
Yes, I would say yes. It could be. A case could be made out in that instance. Because if you are the superintending officer and you note that there is a shortage of an expert in an area and you make no attempts to ensure recorded that the employer ensures that he engages the appropriate expert on board, then I'm afraid that in such instances, the principle of assumption of responsibility could work against you. And your silence on that matter may come back to haunt you. And I think that again is why I think the building industry, what Dato' Yo and his commissioners pointed out is that's where your deficiency is right now. So if you don't have an expert, my advice is that if you need to make sure that there is one. Anything that's not within your expertise, you need to make sure that it's covered by somebody that he's the expert on, so that you can put your reliance on his scope of duty, his expertise, absolving you from liability. Does that answer your question, Zawa?
Yes, thank you.
What else is there? Is there any other question?
Hayao is similar. Then Bunhok has another question. Bunhok Lu,
yes.
What is your view on the obligation of a professional architect to obtain professional indemnity insurance, just like other professions that deal with laws, to make him or herself prepared for any litigation that might have occurred over his or her career?
I'm not sure what type of insurance they offer architects. I recall for lawyers, I think negligence, there is a PI for us. There is a PI for us. I think for architects, you may have. But you see, in this instance, there is more than just, I think it's more than just dollars and cents. My answer to you, Bunhao. I think firstly, you really want to make sure that your own conscience is clear. You do not want to have that weigh on your mind for the rest of your life, that it was something that may have been because people say that and people accuse that perhaps you could have done more. So I think that the reason why we have this talk today is to make sure that you set out and you understand what you can and what you should do, so that you know that all that you can do and all that you have done is within what the law requires and what you only could have done. So that's my first answer to you. Under professional indemnity, I think it's something that your board needs to explore, but bear in mind, that is only to absorb or to cover your cost in terms of dollars and cents. If the negligence results in death, and is in this case, I think that is more than dollars and cents that you are concerned with, which professional indemnity cannot cover, which is the threat of manslaughter. Those are things that the charges of manslaughter. Those because it's formed from negligence. So I think that is more, it goes beyond that, and that's my answer to you. Yeah. What else? Dato' Lo has one. Yes, but
Yeah, to answer Dato' Lo, because this is a webinar session, so it's not possible for participants to unmute themselves and raise the questions.
Yeah.
It's a bit unfortunate on this.
Okay.
Yeah.
I like
allow more participants.
Yeah, I like Bunhawk's comment. Yes, PI, we do have agree, very pricey, agree. Okay. Yes, I think every professional body goes through that, very pricey, even for lawyers, I agree. Some client wants to appoint architect and all consultants under architect. What is the consequence and how to safeguard architects? Yes. Rosita, that is the problem that we face today. That is why this talk is meant to raise to you that awareness, and that is why the commissioner pointed it out. The only way to move forward, my answer, number one, please sort out your undertakings with the council. Make sure that they know when and where these undertakings can be used against the architect. Ensure that that is of the clearest in terms, to avoid further arguments being advanced against future architects. Number two, please also then relook at your agreements. Take note of what the council has pointed, the commissioners have pointed out. Please mark out that although it's appointed under me as a PSP, but this is my duty, I limit to this. I'll be more specific than just condition 1.2. So those are the areas that you do. Number three, make sure that you do not stray onto matters, do not offer and venture any conduct that demonstrates you have assumed responsibility on matters that are beyond your expertise. In our case, our client was extremely very clear. He stuck to what he had to do and what he could do. He did not go beyond, and that made it very easy. If you blur that line, I'm afraid your appointed lawyers may have extreme difficulty. And the last one that I would also then emphasize is that this honor system that MPPP practices, I think that you would, in my view, you would need to look into it very, very crucially and very aggressively, because this choice of serentak, tidak serentak, and then this allegation of non-disclosure, I think it must be put to bed once and for all. So then, in that circumstance, once these are all sorted out, in my view, then perhaps it would be, you can safely then navigate such problems, even in such instances where you appoint all the consultants under the architect. Yeah. Any other questions?
There are some new questions at the Q&A.
I'll be happy to let me just come back to okay, let me see.
Can you see that?
Yes. Can brief on revised limitation act. Sorry, you are looking at which part, what are you referring to, may I ask? I think I will need you to explain that to me. Do I need a break? No, no, no. I'm happy, Bunha, so that you can break for lunch. If I need a break, then you won't have your lunch. We'll all miss our lunch. Maybe Tan, you could perhaps tell me, could you type something for me and to tell me what are you specifically looking at, and I'll try to assist you. I'll go to Lau first. Just wonder, the said contractor in this case was happily out of this trouble at all, despite being the person who actually did the site work. Which contractor? Are you talking about PAMNC contractors, or you're talking about the SAW contractor? There were two contractors. There were a few contractors.
Actually, mainly three parties. We have the earthwork contractor, PAMNC contractor, and the main building works contractor.
So I'm not sure when you say happily out of this trouble. Well, if my memory serves me well, okay, the contractor built their cases respectively on the fact that they relied on the design of the engineer, okay. And in this case, the main problem for the engineer was that when he knew that there were minor landslips, the scrutiny on the remedial works that he undertook was placed a lot of emphasis, and there is sufficient evidence to suggest that what he did was not appropriate and not in accordance with what was expected. That was the suggestion. I remember, and I qualify because this happened in quite some time, but I remember that one of the main issues that was being explored was whether or not there was sufficient soil nails to stabilize the slope, and what was the calculations and all this which he could not produce because there was a reduction in that. Zawa could probably correct me if I'm wrong, but I think that was the thing. So to say whether the contractor, why they were happily out of this trouble, well, they were not happily out of the trouble. They were very much involved. They were asked, but they built their case and navigated it around those lines. I think that was what they took. So that's my answer. Limitation on number of years cover. I come to Dato' Low, whether KM is submitted by planner, the imposed conditions will be reflected in building investment with architect also. Yes, and that is why that is why we Dato' Low, you are correct. That is why I raised that as a concern. At the outset. What is contained in the KM, what are conditions, and what the undertakings that they give. Limitation on number of years cover as in you're talking about limitation of years for negligence. Is that what you're saying? Is that what you're asking, or what? I need to really understand the question, and so that I can answer you, Tan. I'll come back to you. Is there anybody else that I need to address?
Low had another comment.
Sure, please.
Oh, yeah. Dr. Low said he did talk to PAMNC representative who is in the committee who drafted the amendment of UVBL. The person said whatever undertaking architect did in his plan only limited to the responsibility on that plan. Kean Li, you are muted.
Sorry. Yeah, I'm drawing up the negligence. I think the revised is now 3 years from the course of action occurring. So that will be the limitation act that is now applicable in such instances, that any action to be filed and pursued in court against an architect or any consultant for such negligence, they must file within 3 years from the course of action occurring. So that I hope that answers your question. Okay, architect has to state clearly the metrics of responsibility of other. Yes, Dato' Low, you are correct. An architect has to state clearly the responsibility of other consultants. I think that is something that really needs to be revised and be more emphasized after this. Anything else?
Let me check.
Tan, have I answered your question, Tan? Does that answer your question, Tan, about the negligence? That is 3 years from the date of a cause of action. Like in this case, when it happened in 2017, you need to file your suit or your claim within 3 years. Then your time barred, yeah? 15 years for revised act for a project. Okay, I'll look into this. Thank you very much. I'll get back to just a moment. Let me see whether I can explore that for you now. Right. Yeah, I'm having that drawn up right now. Yeah, well, I'm reading the provision right now, and the Limitation Act says that an action to which this section applies shall not be brought after expiration of 3 years from the starting date if the period of 3 years expires later than the period of limitation prescribed in subsection 1. So they gave a few. What I can. Okay, I see your no action, notwithstanding no action after expiration from the date of which. Okay, what I can do, and I will circulate to all of you, is I will respond to you in writing. I will set out under what terms this will happen, so that maybe I give you a fuller answer rather than over the chat. Then that itself, I will provide you the provision and also how it should be applied. Yeah, I'll come back to you, Mr. Tan, I said Tan, Mr. Tan. Yeah. Anything else?
Dr. Law mentioned the PI, professional indemnity insurance, does not give the choice to choose our lawyer.
Yes, you are correct. Yes, you are correct. It does not. Even for lawyers, lawyers that are being sued, they do give you a choice. They do. The choice is within their panel. You can't simply choose any lawyer. You are correct, Dr. Law. So, well, I'm sure that in that panel, there will be many outstanding lawyers who are very familiar with such matters, and they would be more than capable to provide you the advisory. Yeah. Yes. For Tanjung BUNGAH case, the temporary works on slope is only reflected in earthwork submission and not the LCP report. Okay. And all right.
I think
it's just a statement, right?
Yeah, sort of a statement. And on the matters of the town planner challenging on non-disclosure of information, I believe last time we went through that during the submission of the KM or say planning permission, we are required to submit a survey plan which shows the topo, and in our architect's plan with the sketch plan and sketch section, it's also clearly shown that there's a slope and there's some cut and fill involved based on that design. So in a way, the council as an authority who should have the knowledge to examine the plans, right? They should have been acknowledged on this issue, that is a slope side and there's involvement of cut and fill.
Yeah, right. I remember that this, you are correct. I remember that this was actually, if I'm not mistaken, examined by also Dato' Yo, and I believe he used, I'm not exactly sure, but I remember these words that he said, rubber stamp. You're not there to rubber, are you there to rubber stamp along those lines? So I think the main contention is that you have an engineering department. I think that was the issue here. So why do you, if you take the position that despite having very outstanding engineers in your employment, the State Council, which would be more than capable of supervising and approving whatever that was inside there, it would make no sense for you to therefore now say that the architect should be responsible and not you. You wash basically your hands clean. That was also an argument that we used in our submission. I remember using the term contest pilot that you wash your hands clean, and that was what we also used that. Yeah. Yes.
Okay, we have one from Architect Liao. Maybe Architect Liao, you want to speak up?
Yeah, I just want to, Mr. Chan, I
can
just want
hear
to, you can, just want to follow up on the issue about the contractor. And quite rightly, being the consultants, we were thinking, how come the contractor is kind of maybe in a way got off scot-free? Because they are the people who are actually doing the work in terms of cutting the slopes and things like that. Perhaps there is some incident within the SOP of doing the slope that has contributed to the accident and somehow may be involved, you know, in the case, but yet at the same time, the consultants were the ones that actually hauled up, you know, in court. So I just wonder why. It's intriguing to understand why the contractor was not asked more question about the incident, I think.
Yeah, I agree with you. It is extremely intriguing. When we, in our approach for the case from the outset, we thought that the main protagonist in the entire proceedings would be the engineer and the contractors. The developer and ourselves, we would have very minor role to play. In fact, practically no participation. That was what we thought. I agree with you. I mean, based on the contracts, based on the facts, based on case laws, what is established, we really felt that there was really nothing that for us to really we needed to defend. But that was not the case. And I cannot answer why local council, who should be familiar with the demarcation of duties, would go this far as to make such a spirited case against the architect. More so when the senior person from the architectural department, when we cross-examined him, he agreed that when the tragedy occurred, the stop work order and all this, it was not relevant to his department, in short. And yet, when they did their written case after the end of the proceedings, the written case devoted quite a large part of it against the architect. I'm afraid, Mr. Liao, that you would have to really sit down with Dr. Loh or whoever your committee is, to sit down with council and ask them, why did you do this? And how can we avoid in future? Because in my view, it was very, very distressing for an architect. It would be very distressing for an architect to be left in such a position. Yeah.
Because I feel that it's not covering the whole picture.
Yes, I agree. I agree with you. But I guess the contractors had a saving grace, had a major saving grace in that the engineer, the suggestion that the engineer did not demonstrate practice that was normally acceptable in those standards in their industry. It was really it could really be it was very suggestive that he failed in that area. So the guns were turned on him. Had he been able to demonstrate more that he took, why he reduced his saw nails, why he did this and that, and why he did not issue the stop work order, if he had managed to answer those questions, then I think the guns would have turned on the contractors. But that was the position of the case. So in this instance, the facts of the case provided the contractors the defense that they needed. That would be my answer. Yeah. The main contractor totally, yes, main contractor is a sister company. Well, I won't go into the specific details of that case and how those contractual arrangements. I've noted what Mr. Ao and Dr. Loh has said. I think for these purposes of this talk, it's suffice to say that how we have established the contracts. I've taken note also that I think that's a very valid point that Mr. Liao, A.R. Liao has pointed out, why the contractors were given a better right than the architects seemingly. and what you can then do from here on. Anything else that I will need to? Is there anything else, Zawa, that I have not answered?
I think that's about it, except for Dr. Loh did mention that the temporary slope is actually created by engineer, and it's not, is it a permanent slope? Because we may not be able to show the temporary slope in a way which is correct. In our drawings, we always show the permanent, the final look of the site and the building, not the temporary one. So, but of course, during the earthwork plan, it may not be showing fully a temporary slope also, because I think the earthwork is also a permanent earthwork plan, how the final thing will be like. So perhaps there is a gap in this on the temporary slope.
I think that it's good that the industry takes note of all this, the gaps, as Zawa has pointed out, the problems that we have highlighted, and I think something needs to be done as soon as possible. So I hope that this talk benefits. Yes.
Mr. Chan, okay, you were mentioning about the clear line and boundary of responsibility between, let's say, the engineer and the architect. For example, if in the contract for a piling works, the architect has noticed something, let's say, very obvious, but even though he's trying to stay out of the the engineer's realm, as it were, but he writes a letter and say, dear Mr. Engineer, I noticed that there's something amiss in the piling. Can you please see to it? Will that actually mean that he's getting involved in the engineer's work?
In my view, no. If in his experience he notes that something, he suspects that something may be amiss, my response is that no. In fact, he is carrying out his duty to raise a concern. Let me give you an example. It's like, I'm not a policeman, but if I see a crime being committed, I may not be authorized by law to investigate or to stop him, but that doesn't, but it is still my duty, my public spirited duty to report it. So in this instance, my answer to you would be the architect should therefore write a letter to say, I wish to raise this concern, that I've noted this, but could the engineer please respond on this? And so then it puts the responsibility on the engineer. Now, if the engineer does nothing, then there is an issue here whereby the architect needs to take the next appropriate steps, right? Either report it or make sure that somehow or other compels the engineer, reports it to the developer, does all that is necessary to ensure that such a tragedy doesn't occur. If the architect, after having written to the engineer, still does nothing, then you could perhaps, how you frame your letter to say, if you do nothing and if you do not respond, then I will have to exercise my right to issue a stop work order and copy that to the developer. Because we must always remember that consultant architects are independent consultants, although by contract, they are engaged by the employer. So that's why the duty to ensure the safety of the site, that's why they wanted to extend the liability. So in your case, if you have already made it known, the engineer stonewalls you, does not give you a response, then you can absolve by saying that, look, I need to do this. If you don't, and I give you 24 hours. If you don't, I'm going to do this. Something to that effect. So that you force his hand to do something, rather than he just stonewalls you and everybody goes off happy. And then by doing nothing further, there is some concern. So get the engineer to respond to you in writing. Okay.
So really, it's to kind of to establish a very clear boundary that you're not dragged into the realm of the responsibility of the engineer. You see? Yeah. Yes,
you're not dragged into the realm of responsibility of the engineer. You are proactive, because if it's something that is quite obvious, and an architect, any architect in that industry would have reasonably, and come back to BUNGAH's question about reasonably would have noted this and reasonably would have taken some appropriate steps, and you do nothing other than write a letter, then I'm afraid that that could be extended to you. So if you have done something and he responds, fine, your hands are clean now. But if you write to him and he does nothing, then you need to take the next step to tell him that if you don't, I will do this, and I'm copying it to the developer. Yeah.
Thank you very much. Thank you.
You're welcome.
Thanks, Kean Li. Kean Li, there's one last one from Dato'
Sure.
Loh. So
Yes.
regarding the previous comments from Altaya also, that the main contractor is actually also a subsidiary of the developers, but they total sub out. So Dato' Loh's question is, does that relieve the main con's responsibility if the total subcontracting, is a total subcontracting works?
My first answer is that we will have to study the contracts, because it will have to be determined whether that they made it very clear that the principal agency doesn't apply, that the main contractor is not the principal and the subcontractor is not an agent. Because if the principal agency is not marked up, that is not set up, then there could be imputed that the main contractor being the principal and his agent in acting for him, therefore the responsibility, the legal liability will be extended to the main contractor. My second answer would be that, assuming that they made it very clear that I am appointing you and you are to be responsible, I am not your principal, this is not a principal kind of situation, you are appointed and you carried out, then the answer is that, again, based very, very generic, the main contractor could have a defense to say that, look, that's why I gave this job to so-and-so, because that company represents that he has the expertise, and that's why I subbed it up to him to do, and he's fully accountable and whatever undertakings he gives in that sense. But again, that if the main contractor gives any undertakings to take responsibility of the subcontractor's work, any representation in written form, then again, it will come back to haunt you. Yes, that haunt the main contractor. Yep.
Very good point, Kean Li. Thank you.
You're most welcome.
So actually time is up, and
yes.
before we end, yeah, thank you. It's very wonderful that we can spend like almost an hour for Q&A. It's a very good discussion. I have some main takeaway which to sum up this. So what Kean Li has also mentioned, we have to be very clear about our responsibility and qualifications, and never try to assume responsibility where it's not the scope that we are qualified for. And however, because we are the PSP, principal submitting person, we should know what other expertise that are needed in a particular project and ensure that we have the qualified person on board and overseeing what is in their scope. And of course, last, I suppose, is a very good documentation and record. Always keep records of documents clearly. If not, if there's no records, no emails or whatever, all verbal, there's nothing for us to fight anymore. Even our guardian, Mr. Chan, will not be able to help us, right? Okay, so last.
Zawa, can I also, just one thing, I think I owe an opinion to Tan. How do I respond? Can I get the email address to the person, or do I go through PAMNC?
Suppose you can go through PAMNC, or we can
sure.
get Tan. Yeah, I think the best is
I'll go through PAMNC. Yeah,
yep.
Yeah, I'll respond in that sense. Thank you.
Thank you, Chan. Thank you, everyone, for the time here.